My office is funded in part by a grant from the state of Connecticut. The CTNext is our funding vendor, and they are a subsidiary of Connecticut Innovations. So we are in year 4 of a grant, which allows us to do a couple of different things. And I'm going to give you a little bit of an overview of everything that we do to try to give you an idea of what resources you have available to you. I guess this is a little out of context for the way I'm proceeding with this presentation, but I think it's important to note that Fairfield University is a partner with the University of Bridgeport for this grant. So everything I talk about today is available to you as students of Fairfield University, which is really cool. It's actually a really cool resource, and we hope to expand and grow it. So I hope that this sparks some interest for you guys. So the purpose of this grant that the state gave us is to support innovation and entrepreneurship with the ultimate goal of creating new jobs and businesses in the state of Connecticut. So with the money, we do a couple of different things. The first thing we do is give mentorship and guidance on protecting your intellectual property. What is that? That's actually what most of this presentation is about. But to give you an idea of what I do is I go into classrooms or virtually or in person, and I give presentations on high-level IP protection and how that relates to a small business, just to have people start thinking about it, if it relates to them, if it makes sense, how to use it as a business asset. And what happens after that is people usually come to me and I give them specific guidance on what their needs actually are. So then I'll meet with a group or individuals, and I will help make a plan of how to protect your new idea. And we actually have a fund new this year, part of this grant, where we can pay for trademarking your business name or filing a provisional patent application for your new invention. Like I said, this is the first year we've allocated funds for that, and we filed 4 trademark applications and 2 provisional patent applications. I think it's probably a good time to talk about what intellectual property is before I talk about the grant opportunity, if that makes sense to you. So with that, intellectual property is one of those terms that has so much information attached to it. I really want to streamline it so that I don't overwhelm you with information, and hopefully some of it's useful to your business. I want you to think about how you can use IP protection in a way that it adds value to your business. How can you make sure you aren't infringing someone else's intellectual property? You don't want to get sued as a new business. And what really makes the most sense to you? It helps if you think about IP, intellectual property, as real estate. It's just like having real estate, owning a building, owning equipment. It is actual property, except it's property of your mind. So when I meet with clients, one of the first things I talk about is, please think about this as a business decision. Don't think about it as just getting patent protection. People spend tens of thousands of dollars getting patent protection for no real financial benefit. The only way you make money with a patent is if you stop someone else from using it. So a patent is a negative right. It gives you the right to enforce it. It gives you the right to stop somebody from making, using, or selling your invention. It doesn't give you a right to do anything. So you can make money by licensing it, or you can make money by suing somebody, but that is an incredibly expensive route to go. So one of the most important things to think about right from the get-go is, does this make sense for my business? And if you're starting out, a lot of times it doesn't. There's other ways to protect your intellectual property other than filing a patent application. So it's really a strategic business move. It's really different when you're a small business owner versus a big corporation. Big corporations file patents on everything, whereas they have unlimited funds. But here, it's, I mean, hopefully that's your case, but most likely it's not. So with that in mind, let's jump into it. There are 4 different types of intellectual property: trademarks, copyrights, patents, and trade secrets. Each one protects something different. Starting with trademarks. A trademark can be a word, a symbol, a phrase, a logo. Here I'm using a pretty famous symbol. You see the swoosh sign, you see the phrase "just do it," you automatically associate that with Nike without seeing the word. That's the power of a trademark. Nike has dozens more, but these really differentiate the Nike brand, and you don't confuse it with anything else once you see these trademarks. Smells and colors can also be trademarked. The red bottom shoes, Christian Louboutin, the red bottoms of those shoes are actually trademarked. There was a lawsuit a couple years ago with another shoemaker, Yves Saint Laurent, who wanted to also have red bottoms. And there was a huge lawsuit involving whether or not they could. And ultimately, the trademark held its value and upheld the red bottoms of the Louboutins. And anyone that's into shoes knows that's a really valuable marketing tool for this specific company. Without those red bottoms, you can't tell what shoes they are, but as soon as you see them, you know. The second picture there is another really famous item. It is a Tiffany jewelry box, and that color blue is trademarked. It's recognized around the world and identified with trademark. So if you see just by these examples, you could see that trademarks are incredibly powerful in distinguishing these brands from their competitors. And I mentioned a few minutes ago, smells can also be trademarked. And while I was doing research for this presentation, I learned that the smell of Play-Doh is actually a trademarked smell, which is kind of incredible if you think about it, but you smell that smell and you think of Play-Doh. So this is a really powerful tool. How do you protect a trademark? There's 2 ways to protect your trademark. Common law trademarking. As soon as you start using the mark, you have rights. You can use the TM symbol to show people that it is trademarked, but you do have limited rights with this method. For example, if you have a boutique in your town with a catchy name, you name it Sunshine and Rainbows Boutique. You can call it trademarked, but you will have a really hard time stopping somebody in California using the same name for their boutique. But if you take the second route and you register your mark, you're afforded federal protection, which means your name is protected throughout the entire country. You also can use the little R symbol in the circle, and that shows that your trademark is actually registered. A trademark needs to be registered in order to enforce it. And another really interesting thing about trademarks is it's really important to note that they're only protected within their field of use. So again, using my Sunshine and Rainbows example, if that's registered for your boutique, someone that uses that same name brand to sell hand cream in a totally different field would not be restricted from doing so. So the test for whether or not you're entitled to a trademark or you're infringing a trademark is the likelihood of confusion. Now, if you think about it with a Nike, it'd be really hard to use the phrase Nike or the name Nike associated with anything other than sneakers, because as they get bigger, the marks get more powerful. So
Sherri, sorry to interrupt, but
no,
is it
please.
okay if students ask questions via
Absolutely.
the chat system?
Yes, as long as, will they pop up on my screen? As long as
I tried to ask you that question via chat, but I
didn't notice it, but
Yeah.
I see it now.
Yeah, if you open it, then you'll see the chat.
Yeah, I'm going to have that open here.
Should be unintrusive if they send it via chat.
Yep, and if I don't, please interrupt me, because I'm happy to answer any questions as we go or at the end. Okay, Another interesting thing about trademarking is it's really beneficial for counterfeiting. So if you register your mark, it's registered with US Customs, and there's a pretty big effort against counterfeiting in this country. So if you're registered, it's just another layer. Trademarks can potentially last forever. There's a renewal process that I think is about every 10 years. And as long as you keep up with that, you can continue enforcing your trademark. That's different from some of the other areas of intellectual property protection. Moving on to the second category of IP. There we go. Copyrights. Copyrights protect original works of authorship that are fixed in a tangible medium. What does that mean in regular terms? Basically, anything you can create that could be written down or recorded or documented is copyrightable. Registering your copyright gives you the right to reproduce it, to display it, to make derivative works, and perform it. The best way to look at the value of a copyright is to look at it in the context of music. There have been so many lawsuits that relate to copying songs. I'm sure there is a much more current example, which I am going to find, but the one I use is there is a famous lawsuit against Vanilla Ice and Queen because of the melody that was similar between two of their songs. It was argued that Vanilla Ice had infringed the copyrighted material. So your work is under copyright the moment you create it, which is a little different from trademarking or patenting. So as soon as you write something and you put it in a tangible form, which is anything that is written or recorded, it is technically copyrighted. So you don't have to do anything else. That would be the first way to protect your work. But there's a better way to protect it. That is registering it with the United States Copyright Office. Copywriting works is actually a really inexpensive thing to do. There is no review process, unlike trademarking and patenting. You simply file your work with the Copyright Office and it's registered. There's no review process. There is no examination of it. Once you federally register it, you are able to use the C with the circle around it. That is the copyright symbol. That puts other people on notice that it is federally registered. So another interesting thing about copyrights is that they have a life of the author. So if you created the work, you are the author, plus an additional 70 years. When you first think about this, this seems a little odd, but think about it again from the music perspective. If a deceased singer has music that lives on 70 years past their death, their families and their heirs have the right to enforce it against anyone else. Michael Jackson is a really good example of this. His music is forever popular and his family is enforcing the copyrights of his music against people that are trying to infringe it. That can amount to a lot of money. Okay, next, trade secrets. The definition is any information of a business that has economic value that isn't public. Trade secrets are actually what they sound like. They are secrets. There isn't an official way to protect a trade secret. The only way you would do it would be to have non-disclosure agreements, employer agreements, confidentiality agreements, because they are literally secrets. And once they are exposed, there's no way of putting it back. You can't take it back, right? You can't unspread peanut butter, right? That's the saying. So you need to be really careful about who knows your trade secret and how you protect it. Trade secrets could be things like recipes or methods. And you may be wondering what's really the value of this. It kind of seems like a clunky way to protect something business related, but you can see on the bottom here, I listed a couple of really famous, valuable trade secrets. The number one example is Coca-Cola. The recipe for Coca-Cola is a trade secret. No one knows it. Now think of all of the rivals, all the businesses that have been created around trying to copy and imitate Coca-Cola. Pepsi, RC Cola, all the store brands. That is pretty incredible. It's probably the most lucrative trade secret of all time. But there's a couple other ones that I found really interesting. Google search algorithm is a trade secret. The methodology of getting on the New York Times bestseller list, the method of how they select their bestsellers is a trade secret. The recipe for Twinkies, the recipe for the Big Mac special sauce, and KFC's batter. So don't discount this, even though it is not your traditional type of protection. It really could have value. The fourth type is the most complicated, and this is patenting. I'm going to give you a very high level overview of the patent process because
Sherri, sorry to interrupt, but before you go on, I put a few questions into the chat. I don't know if you.
Oh, here we go. Because I'm not sorry. You have to register your website to copyright and protect it. So you do not have to register your website, but if you're going to if you're going to sue somebody for infringement, your copyright has to be protected. My guess, and I don't know the answer to this, I would imagine that when you use a service that creates a website, that there may be some copyright protection embedded in those services. But I don't know, but in order to enforce it, so in order to sue somebody for infringing you, you have to be registered. Your second question, are companies regarded as people? So whoever files that's another really good question. That is another, I don't know the answer to that. I'll have to look at, sorry, I've got the sun in my eyes. I've got this beautiful sunset beside me, but it's blinding. I'm gonna try to move a little this way. A company, I will research that and get back to you on that because I don't know the answer to that. Because
I would cite, for example, individuals who get sued because they go on stage dressed as Mickey Mouse. The Disney company will sue them because they're infringing on the copyright, which they apparently hold for the life of the company. So the company is now regarded as a person at that, you say it's 70 years after the life of the author, but if the author is a company, then it goes on forever and they never lose their copyright.
And that could very well be the case because there are several loopholes with that, with patent law as well, that people or companies take advantage of. There are in trademarking, there is an exemption for comedy. If you are making fun of something, you are not infringing it, which is an interesting point. But yes, your point is well taken, and I will get you a definite answer on that. Copyrights are not my area of expertise. I've spent most of my career just doing patents, which is a beast of its own. So trying to find a better way to do this here. Okay, so let's move on to patenting. Like I said, I'm going to give you a high level view today, but I invite any of you with questions if you think that you may have something that is patentable. I invite you to reach out to me with any questions. I'm happy to spend one-on-one time giving you guidance and coming up with a plan to suit your individual needs. So a patent gives you the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. What can be patented? A process, a method, a machine, a product, a manufactured article, a drug, a new composition, or any improvement on something that's already existing. There are 3 types of patents. They are utility patents. Those protect how something works. A design patent protects how something looks and has 0 functionality, just the look of something. And a plant patent protects a plant. If you think of a patent that sometimes a product can have both utility and design patents attached to it. So think, for example, an office chair that has functionality, maybe it's ergonomic, but also it can have a specific look that you want patented that has nothing to do with the functionality of it. So you can have multiple types of patents on the same invention. A patent has a life of 20 years from the date of filing. After that, your invention is dedicated to the public. Think of generic drugs as an example. Once a patent has expired on a drug, the monopoly ends and other manufacturers are able to produce generic drugs with the same compounds. It is important to note that patent law has changed in the recent years, that the United States is a first to file country. What that means is the first person to file a patent application with the United States Patent and Trademark Office is the person entitled to that patent protection. So how do you get patent protection? You file an application with the USPTO, United States Patent and Trademark Office. There are 2 types of patent applications you can file in the United States. They are provisional and non-provisional. It's important to note that patents are territorial. So a patent in the United States only protects your invention in the United States. So if you're thinking of manufacturing in Germany and selling your product in Germany, you have to apply for patent protection in that specific country. So you must file a patent application in every country you seek protection in. There is no such thing as a worldwide patent. There are methods in place to file in more than one country at a time, but ultimately you have to maintain, which means pay, to have your patent valid in every country that you choose. There is something called a PCT. There is a treaty that I believe 240 countries are a part of, or somewhere around that number, where you can start off by filing a PCT application. It's more costly, and you have protection in all of those countries for 18 months. And then after 18 months, you need to select which countries you want to go into. Some countries further have groups of how they're examined, but a lot of countries have their own patent laws and their own examination process. You pay for each and every one of those. So if you're trying to protect something worldwide, you may be looking at spending $500,000 in doing so. And that's probably a conservative figure. In the United States, it typically costs about, depending on the type of technology, $25,000 from beginning to end. A provisional patent application is kind of a way around that. Or, I just see a question about trademarks. Doug, did you just send me a question about trademarks? Or is that an old question? Yeah. Okay, I just got a question that says, can trademarks last forever? And the answer to that is yes, a trademark can last forever as long as you maintain it. So with trademarks and patents, you have maintenance fees that are due to the US government. And with trademarks, if you keep paying those about every 10 years, it will last forever. With patents, it does not work that way. There's a finite time, it's 20 years, and then you have no more patent no matter what. Okay, so back to patenting. There is a way to make this process more reasonably financially available to a startup or the small guy. And what that is filing a provisional patent application. A provisional patent application has a life of 1 year. It is not assigned an examiner. It is not examined by the patent office. It's essentially a placeholder. So for a nominal fee, you can file a provisional patent application. You can claim your invention is patent pending. You can go out and market it. You can go out and test it, and you don't have to worry about it being stolen. But when that 1 year timeline comes up, you have to make a decision of whether or not you are going to convert it to a non-provisional patent application, which is the more costly option, or it expires and it goes away and it's as if it never existed. This is a really great tool. It's the tool that most small inventors start with because most solo inventors don't have the financial means to just invest $25,000. Like I started by saying, if you look at this as a business decision, if you can spend $1,000, file a provisional patent application, test your product, see if it's really viable, if it makes sense to invest in it, you have a whole year to do so. So patenting is very complicated. And like I said, if you think you have something that is patentable, I am really happy to meet with you and go through it. I have a list of questions that can really help separate and guide you as to what you need to do. The first thing I suggest you do, if you think you have something that's patentable, is do a search to see what else is out there. It's always my recommendation to know your competitors, know what are going to be your roadblocks. You have a duty to disclose everything you know about your competitors to the patent office. So there is really no hiding from it. And if you do get away with it and hide it from the patent office, that company can invalidate your patent. So it's really, it makes more sense to know upfront what you're dealing with. And a lot of times it's discouraging when you see something that's close to what you're doing, but it also can be a really great way to further tailor your invention and come up with a better method that does not infringe somebody else's. So that is my first step always. If you're in a class where you have to come up with a design or fix a problem, your best bet is to know what's out there already. Google Patents. Google Patents is probably the best resource out there. It's really user-friendly. It's much easier to follow through than using the United States Patent and Trademark Office's website, if that's really cumbersome and hard to navigate. A question coming in, does an abandoned provisional patent application establish priority as a person who is first to file? Once that provisional application has been abandoned or expired, it is as if it never existed. There is no priority date. It doesn't stop somebody else from protecting it. It vanishes. If you do convert it to a non-provisional application, then yes, you get the date of the first filing of that provisional. You claim priority to it. So if I file a patent application, a provisional patent application today, October 14th, and I filed a non-provisional on October 13th of 2022, I get to claim today as the date where I stake my stake in this ground, which is really valuable in a competitive landscape. It's the first to file system makes you think that you need to rush and file your application, but I caution you to do that because you're stuck with what you file. And if you file something prematurely, before it's well thought out and really worked out, you may end up with something that's not valid at all, or not have any value. So think about that too. There is quite often someone will come to me thinking they're ready, and once we talk through it, we'll realize that it's better off keeping it a secret for 6 more months so you can really perfect what it is you're doing, and then file a better, more comprehensive patent application, which will have more value and more weight. Okay. Oh, I talked about all this without the slide. Sorry, let's just see. So provisional patent application, life of 1 year, it's not examined, it's inexpensive, it's a placeholder. The non-provisional, it's costly, it's examined, and it's published. That's a good point too. If you decide to go the patenting route, your patent application becomes public 18 months after you file it. So there's no trade secret in patenting. You can't have it both ways. You have to decide what type of protection you want. You also have a duty to disclose the best mode or method of doing something. So you can't just give some details, but not all of them. It is full disclosure. That is the deal with patenting. So when you're filing a patent application, a couple of things to think about in the beginning stages. Is your invention new? Does it exist already? Is what you're doing better, faster, cheaper? Is it meeting a need that is not met currently? Is it better than the state of the art? Would it be disruptive, meaning would it totally change the way we operate, or be an improvement that no one had thought of? When a patent application is examined, you have to prove that it is novel, which means, is it new? You have to prove that it's useful. For a utility patent, it has to have functionality. And you have to prove that it is non-obvious. And that is the strangest wording. But you have to prove that it would not be obvious to somebody else in your field to do exactly what you're doing. That 9 times out of 10 is the biggest hurdle of getting a patent granted. Another question, is an abandoned provisional patent kept in a database? No. An abandoned provisional patent application, well, I'm sure it's kept, but it's never made public. So it would never be found. If you do convert it to a non-provisional patent application, it does become part of the file wrapper, which is publicly available. But that's if you choose that route. If you work on something and you file a provisional application, 9 months later, you say, this is not working, done, I'm totally changing it, stays private forever. A couple of risks I touched on a few minutes earlier. There's the risk of public disclosure. So as we said, the US is a first to file country. If you publicly disclose, so if you present your invention at a competition or to a board and you don't have a confidentiality agreement in place, or you publish, you have publicly disclosed your invention. And what that means is that you've lost all of your international rights. So you have no opportunity to protect it internationally. And in the United States, you have 1 year from that date of public disclosure to file a patent application. So there's a 1-year grace period in the US, but not in the rest of the world. So that's a risk. Filing too soon, we talked about already. That is, if it's premature to file, you're not going to have a solid patent application, and it's probably not worth it if you don't have something that has value at the end. Not performing a prior art search, that we also talked about. A prior art search would be searching for your competitors, what's already out there, the background, know your enemy before you invest in it. Okay, So why protect intellectual property? It could be a business asset, just like real estate or materials. Intellectual property has value. Investors like to see it. It could be a marketing tool. Think about how you feel when you read that something is patented or patent pending. It gives it a different value. Your perception of it changes. Maybe it seems more credible. How do you monetize it? It helps you monetize. Maybe you license it. Maybe you collaborate with a partner. There's a lot of, I invite you to think about this differently as to what the value of it can be for your branding and getting your business off the ground. Is a patent critical for licensing? So you can license a trade secret. So I guess no, but if you have something that's patentable, I would say it's pretty critical to license it. Yes, I think it's probably something that at least have it provisionally. What I see often is if you have something provisionally protected and you find a major corporation that has interest in it, they will license that provisional application and then they will pay for the conversion of it to probably an international application, and they'll pick up the $500,000 tab, which is great. So definitely important. This is my favorite example, borrowed from the United States Patent and Trademark Office's website. This shows how a single device can take advantage of all IP protection. If you look at the picture on the screen, everybody knows what that is. It's an iPhone. There are hundreds of patents on this singular device. Everything's trademarked. The Apple symbol, the iPhone name, the software. The patents inside are for the touchscreen, the battery, the antenna, the housing. There's even design patents here, right? There are like the design, the shape, right? Samsung and Apple have slightly different shaped phones. Those are protected with a design patent. The surface, the finish, the colors, all the software is copyrighted. There has to be algorithms in there that are trade secret. So I think if you want to see the value of a company taking advantage of intellectual property protection, this is a perfect example. So that is the end of my intellectual property overview. Does anybody have any questions before I move on to talking about the grant? Are there CTNext? There's a question that says, are there CTNext resources that can help with licensing? Currently, we have a contract with a business attorney that is assisting faculty and students with doc review, sub-license agreements on a somewhat limited basis. So the answer to that is yes, but we do not have an unlimited budget to do that. What the grant resources can do is assist with filing a trademark application, filing a copyright, filing a provisional patent application, starting your business, contract agreements, so organizational agreements within your company, reviewing license agreements. We do not have the resources to do a contract negotiation right now. There's a question that says, is there a licensing agent that can help get the IP in front of the right company? So in bigger tech transfer offices, we do have agents for that. Right now, we do not, but what we do have is a pretty broad network of we have entrepreneurs and residents that sit in our innovation center that have connections to outside businesses We also have an industry advisory board that is another really good resource. So I would say right now we do not have a licensing agent. Down the road, as we grow, hopefully we'll be able to get more funding and hire another person. We just filled out our application for year 5 of this grant. We partner with Fairfield, Housatonic Community College, and Norwalk Community College. This year, we are adding on Gateway Community College and Wesleyan University, and possibly Sacred Heart. So we are greatly expanding the program, and with that comes a greater need for help and resources within the University of Bridgeport's facility. So I would love to have a licensing agent. The issue with licensing agents are that they typically specialize in one area. So it's hard to, it would have to be a very strategic hire. I think it's probably better to use resources on an individual basis to try to make those connections right now. So let me tell you a little bit about the grant. So the grant can help you with these types of business opportunities, but also what it can do is give you a mini grant or an innovation grant, which we give out. We typically give out 10 a year. Next year, we're aiming to give out 20. So we're looking to double the amount of grants we give out. They are in the amount of $5,000 each, up to $5,000, and they can be used for anything manufacturing, prototyping. They can be used for further research. They can be used for market development, anything that brings your product closer to market, they could be used for. The way you do that is fill out a grant application. I can send you a link to it. Professor Lyon, I believe you have it, but I can send you another one of those. It's fairly straightforward. You basically talk about your project. You talk about your milestones, which are your goals. The grant is 1 year. So what are you going to do with that money in that 1 year period? How will you spend that money? We want a breakdown of how that money will be spent. And basically, that's a description of what it is that you're working on and how you're going to have a business around it. So it really is, I guess that's an important part of it. It's important to note that these are for the purpose of starting jobs and creating businesses in the state of Connecticut. So the grants need to be with the focus that your goal is to ultimately start a business in the state. I will send a copy of the application. I don't know if I could do that while I'm on this. If I stop sharing my screen, I may be able to do that. So we typically grant about 75% of the applications we receive. If you have something you think may be, if you think you may have something that is eligible for this grant, I encourage you to apply for it this year if possible, because I can tell you we have grant money to spend in this last quarter. So I would love to see some more applicants. We've given out 31 grants that's this long in the past 4 years, and 14 of those are to our partner schools. So there are quite a few grants we've given out to Fairfield already. We look to give more and hopefully support you with other intellectual property needs. I think that is everything that I can think of. Can you think of anything else that I'm missing here to touch on? I will look for this file to send. Hopefully I can do that here.
Yeah, if you could share your screen, maybe we could see where the form is and perhaps ask questions about how to fill it out, if there are any.
Okay, let's see. Let's see. Okay. So I will share my screen once again and show you. This is what the application looks like. Like I said, it's fairly straightforward. So the principal investigator would be whoever is leading the project. We ask that you are tied to a faculty member. That could be an entrepreneur in residence or one of your faculty that you're working on. I think it's important to note that being a part of this grant does not make you give up any ownership rights of your intellectual property. There's no ownership involved here whatsoever. This is purely money for you to spend to further your business in Connecticut. So an abstract, a summary of what your project is, a background of it. This could be attached, or you could just put it in right here. Talk about what the problem is, a description, what is the unmet need, what problem are you solving, what is the market size. This is probably the most important section here. What are your experiments and your milestones? Basically, what are your goals for the next year? You can go beyond that, but like I said, the grant is 1 year. So within this year, what are you trying to achieve with this grant funds? Do you have any intellectual property? It's important to note that you do not have to have any intellectual property in order to be eligible for this grant. You can have potential IP, you can have future IP, but you do not have to have it. It's not a make or break deal. Are you collaborating with anybody else, any other schools or companies, and any publications that are relevant to what it is you're doing?
Where's the URL for this one?
The URL for this should be on our website, but I believe our website is being revamped at the moment, so it may not be on there just right now because we have.
If you could send it to me, then I would post it to our Blackboard course
Perfect.
management system. That way they can, all the students can find it.
Perfect. I can absolutely do that. This is the other most important part, which is the budget. How are you going to spend the money? We have it broken down here. If it doesn't fit into this table, you can explain how you're going to use it other. And then below it is really the justification of the money. So you can't just write experiments. You have to explain what experiments, how they're going to be used, tie it to your milestones. We want to really see you have to report at 6 months and at the end of the year. So we really want to see that you are achieving what you set out to achieve with the money. So this is just the breakdown of the costs. And then we ask for a resume to be attached. And that's really it. So it is pretty straightforward. And if you have questions while you're completing it, I'm happy to go back and forth. So it could be a complete application. We hate to see something rejected because the form wasn't filled out completely or it wasn't clear of what exactly the purpose was.
And for those grants that are rejected, do you happen to have any insight into what are some of the more common reasons for the rejection?
I would say sometimes it's not clear of what the business plan is going to be. So if it's purely research based and you're really far from starting a business, I've seen those rejected. I've seen them rejected if applications, I've had people just attach a thesis and not take the time to explain how this money will be used. Those types of things. I think we don't like rejecting applications. We want to give as much money as we can to our UB and our partner schools. So I think if you put the time into it, and if you work with me or you've been through the process as well, so you know what we're looking for. So these are reviewed by a committee once they're submitted and they're scaled. and then a decision is made for them to be granted or not. And sometimes, I'll tell you this, sometimes when I get the comments from the committee, I'll go back to the applicant and say, if you can explain this section, here are my comments I've received. If you can explain this section better, we can award you this grant, which happened actually very recently. So it's not a done deal. We're flexible and we want to work with you. We're here to help, right? That's the ultimate goal. So
I think there were certain criteria that reviewers were asked to evaluate the grants on, such as market need, innovation and novelty,
yep.
funding
So
and commercialization, and scientific merit and feasibility. Those were
so we try to match the way they're critiqued by the questions that are in the grant application. So yes, they are reviewed based on different categories. They're equally weighted, and we have such a wide spectrum of businesses we've supported that I would say if you apply and you have a well thought out plan, the chances of you getting this grant are probably really good.
So, for example, I see some projects coming in with relatively small total addressable markets, which would give them perhaps a poor score on the funding and commercialization potential scale. Would that kill the grant, do you think?
Not necessarily. Not,
Okay.
I don't think necessarily that would kill the grant, no.
And also, sometimes I think the senior projects are perhaps regarded as routine engineering. That is, they don't have, they're not research, right? They're development. And so they may be even advanced product development. So scientific merit and feasibility, they would be feasible, but it's not, it doesn't necessarily feel like science. It feels more like engineering. That shouldn't kill the grant, should it?
No, not at all. I would say, so this is a senior design class. I would say probably the biggest hurdle is that if you're graduating in May and we lose track of you once you graduate, that's probably the biggest problem. So if there's seniors leaving at the end of the spring semester, my recommendation would be, when you fill out the grant application, to use all that money prior to your graduation. So your grant probably is 9 months instead of a year.
That makes sense.
Yeah,
That sounds
because
like a good idea, because you need to get the funding and the commercialization part of this grant done by May so that you can go hire yourself in this new business that presumably you've constructed.
right. And we've learned that the hard way over the years. People graduate and they're gone and they still have grant funds. And it's hard to, once you're working and you're out in the real world, it's hard to. That's also why we tie students to faculty.
Gotcha. That makes great sense.
Yeah.
Are there any questions? I think I've been asking all the questions. Are any questions from the audience, the students, or whoever else is in the audience? Well, then I hope everyone will join me in thanking Sherri. Sherri, I thank you. This has been a great presentation.
Oh, good.
I've been recording it, and I will send you a link to it after
Oh, thank you.
the thing gets transcoded. And I would ask that students hang about a little bit so that I can go over the homework assigned, just in case they have any questions. So thank you very much. I appreciate it.
Thank you for having me. I hope soon I'm able to be there in person.
Me too. Me too. Sorry,
right.
sorry, we're still locked down. It's
No,
a COVID thing.
This is better. Hey, I'll take it. Thank you for having me. It's great to see everyone virtually. And please feel free to reach out if you have any questions.
Will do.
Thank you so much.
Have a good night, guys.
Good night. All right, everybody. So let me ask before you go, if there are any questions about the homework, which is due tonight. We gave everybody an extension because we had a little issue We wanted to make sure that the TAM, SAM, and SOM all had dollars associated with them and that the profit margin was expressed as a percentage. I think there may have been some confusion about that. Are people okay with that now?
I do have a question.
Sure.
With our project, we're for the biomechanics STEM outreach. We don't know how to find a way to like measure it in money and dollars,
So that's an
because
interesting
we're not
question.
creating a single product with clients like that are gonna buy anything.
Well, now let's think about this. You have the physical therapy market, right? Somebody's got their mic open. Could you mute the mic if you're not asking questions? So what we want to know is, not necessarily your specific product when you do total addressable market, but perhaps the physical therapy market, which could be huge. And you know that what happens in the world of insurance is you must show progress in physical therapy or else the insurance company will kick you out. So if you have something you can digitize, such as the range of motion, and you can calculate the range of motion and show that it's improving as a function of time, the insurance will continue to pay. So this is a big deal. And so it's one of those things that was made as a point to me by someone who was the director of chiropractic at University of Bridgeport, Steve Pearl. We had these discussions long ago, years, decades ago. And now it may be with the mechanisms in place, such as the iPad and image processing, you can automate the range of motion digitization and prove to the insurance companies that people are improving and thus can be maintained in their physical therapy regime. So this is a big deal because when we think about the total market for physical therapy, it's huge. And all the physical therapists, when they work in an office, there's an enormous amount of people working in the back office doing paperwork all the time. There's people who are, we'll call them insurance processing professionals. They know all the codes. They know how to apply for all the insurance. And without the insurance paying for the physical therapy, a lot of times people couldn't afford it. So they need that insurance to continue to help them get better. And so this has got, important, useful social qualities associated with it. It helps people get better. It helps get them get the physical therapists paid. They need to get paid in order to continue working. So there's all these interesting things you can take into account when you're calculating something like the total addressable market. And then, and you can use Google for physical therapy market. I mean, it's huge and it's growing because there's people who are getting knee replacements. There's generations of individuals who are essentially having their joints kind of degrade as a function of time. And it's just, we'll call them, elder care facility people. And so that's a huge total addressable market and a growing one. And then that kind of addresses what business you're in. And then when you go to the serviceable addressable market, right, this is the part where you're going to say, well, what's the geographic reach for what we're doing? And, if you just restricted yourself to the United States, that would be huge. And then if you said to me, well, let's look at the, competition and maybe people's willingness to pay, all of a sudden you've got, all these physical therapy organizations who might be interested in paying you. And then comes the serviceable obtainable market. And now what you're trying to do is pare it down to a smaller segment that you can target specifically. And if you wanted to just do something like local physical therapy organizations and then grow this organically, each one would have a limited capacity, but you could presumably go there and show your product and they would then see that it's good and you could give them a free trial. And then you grow the system in an organic fashion. And, that could be something where it's sort of like you're maybe the only mechanism in town where you're actually offering to give people an opportunity to try your stuff. And that's where you get your customer feedback. And then you can improve the product some more. And then word is going to get out. So you can go in staggered phases and essentially grow the business in a city by city and then state by state means. And so that's a great way to sort of test your marketing strategy, test your product, and reach your target market. It's kind of like a guerrilla marketing system that also lets you get feedback about your product and allows you to improve your product as you go, because you really need that feedback from your customers. Does that make any sense?
Yes, yes, I think it helps.
Oh, good, good. So then, any other questions about this thing? And we ended up with the gross profit margin at the end. I think somebody asked me, what's the basis for gross margin? And I said, well, it's gross profit margin. And I showed some examples of how you can do the computations. Any other questions about the homework due tonight? It was some people have already finished that homework and we're going on to the next homework assignment. I'm going to see if I can share my screen here. I think I can do that. Let's see. And what we'll do is we'll take a look at.
Professor.
Yes.
On our first attempt at homework 5, you had said that Sam and Som need to be in dollars. Do you not want any writing for Sam and Som? Do you only want numeric values?
No. There definitely should be writing, but we should have some dollars. So see, people don't understand about widgets. When you go to a venture capitalist and you say, we're going to make 1,000 items, they don't understand the value. So the value add is going to be given in dollars, because that's what people understand when you go to pitch for money. So when you give the total addressable market and then pare it down to eventually the serviceable obtainable market, you want a number that is going to hopefully impress your backers. So when I did a CTNext grant, and I think I put the sample up there for you guys to look at, we basically said you can look at Apple as a example of an app store. That's a $67 billion a year business for Apple. Now we're going to do a Java app store, and Java is 6 times bigger than iOS because iOS is programmed in Swift and Objective-C, which relatively few people program in relative to, let's say, Java. And so we say it's 6 times bigger than the Apple potentially. We have this serviceable obtainable market, which could be, I don't know, $180 billion. It sounds insane. Could be bigger. I don't know. So I'm thinking, well, what's the profit margin? And I say, well, all we're doing is deploying somebody else's software and taking a piece of the action. Profit margin's huge, right? After you get through the one-time engineering costs. So now all of a sudden, it's beginning to look like an enormously viable business. Now, in comparison, if you're shipping widgets that require chips and you have trouble with supply chain management, you have to ship the widgets out the door and you have to pay for shipping, it's a whole other kind of business than this signing other people's software business, because in principle, you don't even have to do a whole pile of software development, right? You can essentially let somebody else do the work and you just rake in the money by running a platform and making connections. That sort of makes sense. So
I guess more of what my question is, like, how would you put a value on a project that's for research and teaching purposes, not really for selling items?
All right, so let's assume,
because for the project that I'm with Dr. Balaji with the end-to-end FPGA transmission from a transmitter to a receiver. That's not, that's more so to teach applications of communication systems. It's not really for like large scale market. It's more so to teach engineers for something for a resume
All right.
and
So
prepare communication engineering.
yeah, this is a demo of the deployment system using WebStart, and this is a Java 3D application running in real time. Now, to answer your question about, you know, the education market, it's huge. We actually did an example with the car. I think there was the LiDAR based car, and you know, it's a widget, right? So if you think about sort of like LiDAR systems, they sell. Little robotic cars, they sell. Now we have the, you know, this idea that you can have the world's cheapest LiDAR based car, and if you can do it for like $20, I think it, you know, it'll sell big time for Kickstarter if you can make enough money on it. But now you're saddled with having to ship actual hard goods, and so it erodes your profit margin as a result. And so when you're shipping hard goods, you have to do something to make it ship properly. You have to do something to make it ship cheaply. You know, if you can do the whole thing and ship it as a flat pack, that kind of makes a difference. So when you go to, you know, the laser cut system, you know, what you're doing is you're essentially getting something which may be the size of a sheet of paper and made out of wood, do the laser cut and let somebody else do the assembly. You can ship that whole thing in, you know, a stiff cardboard envelope. But if you're going to have to add some motors and some wheels and some servos and a little LiDAR system, all of a sudden things require a box. And now it's a lot harder to ship, and your profit margin starts to erode quickly unless you can raise the price. So you have to see if you have sufficient pricing power to make a feasible business out of it. And that's the intellectual exercise that you go through when you start to write down your cost of goods, your cost of assembly, your cost of shipping, and figure out what you need to charge retail in order to be able to get the products out the door. Then compare against, you know, what other people are charging for their cars and say, oh dear, we're going to have a problem, right? Because if you can go to Amazon and look up robotic Arduino car, maybe you can find there are already these things available. And here's one with a little swivelly, you know, ultrasonic sensor. And here's one with a camera. And this guy's $49 and that's $100. And it looks like they're selling. I guess it's educational. You know, people can certainly buy remote cars for much cheaper, but look what they're charging for these things. You know, $100. They seem to have pricing power. And here's just the chassis with no computer and no sensors at all, and it's $21. So at some level, one could make a compelling argument that there must be a market for these things. Here's one that's looking like a tank. And these could be a lot of fun for somebody, and perhaps this is the educational market. Here's one with the laser cut chassis, and we could cut that in the shop. And in fact, if you wanted to, you could outsource many hundreds of pieces, right? If you have a credit card, you type in the number, you can get 400 pieces made and they'll make it for you, no problem. And I've done that actually. I had manufacturing done. So it's not unreasonable. Here's somebody who got, this looks really complicated. They've got a little robot arm with several degrees of freedom. And it looks like it's got a remote. And it looks like it's got an ultrasonic sensor and a couple of geared motors, DC motors in the back. So these are Mechem wheels over here. These allow you to turn on a dime. Essentially, you can swivel these left and right. I don't know if you're mechanical engineers here, but there should be some, and you'll know what I mean when I talk about the Mechem wheels. Normally, you have what they call non-holonomic constraints, which means the things roll without slip, which is why you put a caster in the front. But here you can actually make it so that the wheels will slip sideways deliberately. That's what Mechem wheels do. They're a little more expensive. These wheels, of course, they're not meant to slip, but they will force them to slip because they'll turn them. So that's interesting. Lots and lots of educational kits, all being used for robotic cars. None of them have LiDAR. Where's the LiDAR? You know, I think it should have it. And if you think about like modern, you know, Teslas and stuff like that, there's no reason why you shouldn't have a little LiDAR system, because they can be cheap. Why not? So I think we'll have a niche market with a LiDAR car, and it'll be an educational market. And maybe we don't have to charge a whole bunch more than the $18 or $25 that we see here commonly advertised for cars. This one's $15.95, comes with a whole bunch of stuff. I bought one of these. Comes with the caster. So that's good. You guys, you know, you have an opportunity, I think, to express the TAM, SAM, and SOM, and that will become an important feature in your CTNext grant application, which I'm hoping we'll be able to apply for soon. So that's about all I have time for today, unless there's any other questions.
Professor, isn't the CT space grant, isn't that due tomorrow?
You're talking about CT Space.
Oh, is that a different?
That's different from CTNext. So
Oh.
Sherri was representing CTNext. That's the entrepreneurship grant. So yeah, CT Space grant, that's got to be NASA related, I should think. And you know, we were going to do something with the high altitude weather balloon, but nobody had a good interest